First of all, you cannot file the I-130 and I-485 concurrently at the same time. You would need to file the I-130 first, wait for a visa to become available by checking the priority dates, and then submit the I-485 application if you're eligible. Hey guys, so there's been a major update to the Visa Bulletin for October 2025. Specifically, the F2A category, which is for spouses and children of permanent residents, has a priority date of September 22nd, 2025. So for anyone watching this, if you file an I-130 petition for your spouse before September 22nd, 2025, then as of October 1st, your spouse might be eligible for adjustment of status. But remember, this is a preference category, so it's not the same as adjusting status through a US citizen spouse. First of all, you cannot file the I-130 and I-485 concurrently at the same time. You would need to file the I-130 first, wait for a visa to become available by checking the priority dates, and then submit the I-485 application if you're eligible and when the visa becomes current. You must maintain valid non-immigrant visa status to adjust status in a preference category petition. So let me give you a quick example of someone who might be eligible in this situation. In this example, the immigrant fiance enters the US as a tourist, and then in September, she marries her permanent resident spouse. And then the permanent resident spouse files an I-130 for the immigrant who's here on a tourist visa before September 22nd. Then on October 1st, since the Visa Bulletin shows that I-130s that were filed will be current, the immigrant spouse would then file the I-485 application for permanent residence. The key here is that she's still in a valid non-immigrant visa status. She's still in her 6-month duration of stay on the tourist visa the moment she files the I-485 application. Unlike ordinary immediate relative category petitions where the immigrant marries a US citizen, in those categories you can be out of status. But when you marry a permanent resident, you cannot be out of status. You must be in a valid non-immigrant visa status the entire time before you file the I-485. After you file the I-485, the application for permanent residence, it's okay if the tourist visa duration of stay expires, as it would. If she entered in June, that would have expired around December. Given current timelines, it's possible that she might even be a permanent resident in this scenario by December because things are moving really fast. But the key here is that she was in a valid non-immigrant visa status on the day that USCIS received her I-485 application, and a priority date on the I-130 was current. So in this scenario, notice that we didn't file the I-130 and I-485 concurrently. We didn't file them together. We had to file the I-130 first and then the I-485 later. If you're new to my channel and what I'm saying sounds like gibberish to you and you don't understand any of this, please schedule a consultation directly with me. I would be happy to run you through how these scenarios work. You can find my information for scheduling a consultation directly in the video description below. We handle family-based immigration cases, naturalization, and immigration court proceedings. So if there's anything that you need assistance with, please reach out. We would be more than happy to assist you. And for those of you who want to stay up to date on immigration policies and what's happening on the ground from an immigration lawyer's perspective, be sure to subscribe to my channel. I'll put out several videos each week on these topics, and I'll see you guys next time for another video.